So I'm James Richardson. I'm the chairman of the CIR Thames Valley branch, and we're hosting this meeting today, as I'm sure you're all aware. Now, just briefly, we're CIR Thames Valley, but we're not all arbitrators. Many people in the room today, I'm sure, are from a construction background, but not necessarily arbitrators. Lots of adjudicators, lots of expert witnesses, but also just professionals in the construction industry and wider industry. Today is a construction event, but very important that we're not the Society of Construction Law. We're the Chartered Institute of Arbitrators, and actually what we do goes much beyond construction. We're just very fortunate today to have a very, very good construction talk. Now, we've got about 240 members, and the important thing, and I'm going to come on to these shortly, is the events we hold, because that's really what we're all about as an organisation or as a branch, is hosting these events. I think I'm sure on behalf of the committee, really pleased with the number of people in the room today, and to know we've got over 100 people online is really, really good as well. So really pleased. Then I'm going to just take us through in a few moments some of the things we've got coming up over the next few months. Generally we don't do anything in August, but as I say, with the JCT, the new suite of JCT coming out, it was such a great opportunity that we couldn't help it. But we've got quite an exciting, or what we hope you'll find to be exciting, program of talks and events through the autumn. So we're really pleased to have that. And it's going to start on the 18th of September back here with Will Minting talking about neighbourly disputes. So hope to see some of you there as well. And this is a bit more of a construction one, but a slightly broader construction topic perhaps. And then we'll be hosting an expert witness seminar, which will be run by Mark Thomas predominantly of the RICS expert witness course, and much experience as expert witness, but with a number of guest speakers as well. So we hope many of you, perhaps even beyond the construction sphere, will find that very interesting. And then just briefly to touch on what we have coming up after that, on the 16th of October, we've got a talk regarding adjudication by insolvent companies, which is quite an interesting topic. And then we'll have another one, and this is really building on a talk we did previously at the end of last year, I believe it was actually now, regarding mediation. So again, a topic going beyond construction, but very relevant to construction and concerning some of the recent changes and the prominence that mediation is now gaining. And that's really the end of what I've got to say, other than to introduce Karen Kirkham, who we're very pleased to have coming to speak to us today. She's at BDB Pitmans and heads up their construction, but that really is the beginning of her qualifications to talk to us about the JCT tonight. She's the chair of the JCT, I believe, in your second term, and has a wealth of knowledge on the topic. So I'm really pleased to welcome her here today to speak to us. And all I will do now is change her slides over and ask you to join me in welcoming Karen. So thank you.
Thanks very much, James. So I'd like, if I may, to share with you my passion for the JCT, which has been a constant throughout my professional life. That's no exaggeration. So I'm now JCT chair. I'm a solicitor in private practice. I am not a litigator. I am not an arbitrator. I'm not an adjudicator. Please be very gentle with your questions, therefore, if they tend towards the contentious, although I like to say I do non-contentious, but it's not uncontentious. I'm a non-contentious construction lawyer. The majority of my construction clients are developers or occupiers, with some architects and contractors, but those are a minority. I'm a client person. I've worked with the JCT since 1996 when I was legal director at the Construction Confederation. So it's been a sort of lifetime project for me in different capacities. This is now my second term as JCT chair. I was mad enough to sign up for a second term of it. I'd like to tell you how I became JCT chair. I think it says all about the JCT. in 2020, I went on their website to try and find some useful guidance on amendments for COVID, and I didn't find any, but I did find the post of JCT chair being advertised. And it was an entirely mendacious advert in that it said it would be 5 days a year. I've since had to give up a full-time position, and I'm no longer a head of construction at BDB Pitmans. I've had to go to 4 days a week so I can fit in the JCT around it, which is my pleasure to do and my passion. So sorry, I did say there weren't any animations. Clearly, it's a lie. Principles. Amendments to the JCT contracts are achieved through consensus by the member bodies. That's why it takes such a very long time. It's taken a particularly large amount of time between editions this time because, first of all, there was COVID, people weren't having meetings, then they got used to doing them on Teams, and then we'd waited so long that we thought we may as well wait for the Building Safety Act regulations to come along. So it's been an unusually large interval. I don't know how I begin to describe how difficult it is ever to achieve a consensus between contractors, employers, subcontractors, consultants, etc. I would say they were civilized squabbles, but they are squabbles, so that it's a very long process, and everything is mediated not only through consensus, but through some of the best minds in the industry. So Victoria Peckett, who was at CMS, is now at Clyde's, is the chair of the drafting subcommittee, and you know, Suzanne Reeves, there are some amazing quality people. I should say that I've taken full credit for these slides. I would say that they're not very consistent in their formatting. They're not my slides, they're my slides and about 10 different colleagues' slides, including John Rich's, for whose credits I have carefully removed from the presentation. I think you may know John, he's an arbitrator. He's vice chair of the drafting subcommittee and also my fellow board member and close colleague. So they represent input from the full range of industry sectors, discuss, private and public sector clients, main contractors, subcontractors and specialists, not quite sure what the difference is, ROBA, RICS, we seem to have lost ACA in the mix at some point, and the mixed sector Scottish Building Construction Confederation. So it's quite a large group of cats to be herding. Principles, once again, the contracts are there to spell out the legal rights and duties of the parties. They're not supposed to be a societal charter. I know a number of people were concerned that their favourite amendment wouldn't make it in. There was somebody who wanted us to put mental health clauses in. It's not about shoehorning things to do with social policy. It's to do with what are the rights and responsibilities of the party. And if you get John Richards on the subject, he will wax even more lyrical than I do. If you want, I can't do a John Richards impression. If you want the technical stuff, it needs to go in the contract documents, not in the terms and conditions. So we both agree very strongly about that. On the basic principle that contracting parties must comply with all the relevant law, we make the bare minimum of reference to specific legislation. So there's controversy over whether it's the right amount of building safety stuff. And I have seen, I mean, I don't get involved in the drafting of the contracts. I'm not actually allowed to have an opinion as chair. And the last thing that JCT needs is another developer lawyer putting the law in. I have subtly influenced some of the decisions. But building safety stuff, it was the last thing to be finished pretty much, and it's been in and out of the contract like the okey cokey, and we've come to quite bare minimum references, which I think a lot of people think is correct, because we don't go into, for example, the Arbitration Act in huge detail. We don't go into CDM in great detail. We don't go through it. I tried before a seminar to count the number of implied and expressed statutory references in the contract. I gave up counting at about 50, I think, probably. There's a lot of law in there. It doesn't need to be stated in full. We don't use any procedural matters or secondary obligations. So if you're doing a building contract for one of the public authorities and they want to tell you how much you're supposed to pay your staff and what your industrial relations are supposed to be like, we're not going to put that in our contract. Glad to get that off my chest. Reference to technical scopes and social policies belong in the other contract document below the line, possibly in the prelims, but no further up the hierarchy than that. You might be able to, I feel strongly about this. So what did we set out to do? We set out to do a number of things, including future-proofing. So construction playbook, I don't know how many of you have dealt with construction playbook. There was a malicious rumour put about that we were not compliant with it, and we had an analysis done by the gentleman that used to be Peter Hibbard, the chair of the JCT, and he found that we are pretty much compliant already, but we have made some further changes to emphasise our compliance.
Karen, could you explain for people who may not know what the construction playbook is? It's always worth.
Okay, well, the construction playbook is a government document which sets out the standards in general terms that construction contracts for government and public authorities are supposed to comply with. And it's, I think, probably realistically very much looking at people entering into NEC contracts, because a lot of infrastructure contracts, I do them myself, are NEC contracts. And therefore, a belief has grown up that it is all a bit politically correct. I mean, it is worth having a look at. It's quite easy to get hold of. But there is this belief that JCT doesn't comply with it because JCT is only interested in these filthy commercial contract issues. But we had looked at it and we're mostly already compliant. It is genuinely worth a read. I think it might have been compiled with government and the help of Denton's, Boohis. Principally for public sector, but also best practice for private projects where applicable. There are 14 key policy areas. JCT contracts already complied, but more emphasis is now given to collaborative working, sustainable development and environmental considerations, notification and negotiation of disputes. You'll have noticed that those things were already in the contract, but they were optional. They are now mandatory insofar as anything in JCT is mandatory, because you can get rid of it if you don't like it. Please don't amend our contracts under any circumstances. That's, I never do. Obviously, that's a lie. So looking at these specific issues, collaborative working, it was previously supplemental provision 5. I'm going to go for this quite fast so we could get bogged down. The wording has not changed, but now appears in a specific article at the beginning to direct your attention to it. And there is case law to suggest that this is all enforceable, which is, that's the reference there. You will get copies of the slides afterwards. Duty to act honestly, not in bad faith. Prohibit conduct that is reasonable and honest people would regard as commercially unacceptable. Good luck. Sustainable development. It was previously a supplemental provision 8. It's now in clause 2.1.5 at the end of the clause. That's slightly at odds with me saying that no social policy. I think that was done specifically with a view to complying with the construction playbook. So a small change to 2.2.2, and there's more detailed provisions in the PCSA if you're working with the contractor to do detailed design. I should have said, can I bring your attention to this marvellous product for this marvellous publishing company of which I am director. This is JCT tracked changes. This is the DMB one that came out first. I certainly read it back to front and before I did any talks on the subject, and it's a very useful product. Notification and negotiation of disputes. There's a fallacy here, we'll come to it. I'm sure you'll bring it to my attention if I didn't say anything. Supplemental provision 10, view to avoidance of disputes or differences. It's not a condition precedent. I don't know how I feel about that, because nothing can get between a girl and her right to adjudicate. So I'm afraid it's got to be window dressing, because you can't raise any barrier to be able to adjudicate. So Notification, negotiation of disputes at 9.1 is now mandatory. The caveat is that the Construction Act doesn't allow any barriers to adjudicate at any time. But we could have a philosophical discussion. What are contracts for? To me, they're partly about behavioural modification as well as what is strictly enforceable. It's directing your behaviour and your attention to the correct way to behave. Other updates. Gender neutral language. I mean, I'm sure we'll get just as many satirical comments as people make about NEC being the present tense. You know, the project manager and the contractor agree on extension and then they go to the pub in the present tense. Gender neutral language rolled out across the entire suite. It measures the approach taken by government to the issue. The masculine he pronoun is replaced with it or they. I do find it useful in drafting if you stick to that rule, because otherwise you can't remember whether even in an email your contractor was and they and it, a he or a she. And of course, the contract administrator is always he, isn't he? It also ensures that the format and language of the contract will remain familiar to regular JCT contract users. It's a small but significant change, and we're trying to be more inclusive. Anybody else used a fluctuation clause in the last 30 years? No, they've been shunted out of the printed document and put onto the website. That doesn't mean to say you're not supposed to use them. Although any time I recently tried to use one, the developer sacked my contractor client. This is controversial for the current audience at home and in the room. We didn't put in all the different nominating bodies for adjudicators that various people wanted us to include, because we took the view that it's just easier to say use whoever you want. It wasn't so much that we were worried about who we were including. There was controversy over Texer, because you would think Texer was a no-brainer. But if you're going to include new people who you are going to include, then you have to have a set of criteria for people you were going to exclude, and we weren't prepared to put the time into that. The people who are in there are the people who were in there already. It's not made everybody happy. Gender neutral language, you know, why not really? I mean, I have heard the odd Saki comment in JCT Council. I did nearly whip out in evidence my gender non-binary trainee, but it never turned out to be necessary. So. There's once again, why? Behavioural modification. There's theories around the use of language, neuro-linguistic programming. You will not in future be sexist about your assumption about the gender of the contract administrator, etc. So there can be unconscious bias or assumptions underpinning the use of language in contracts. And having to revisit whether your contractor is he, she, or it's a bit of a pain. There's miscellaneous housekeeping amendments, so fluctuations out. Contractor design provision has changed to include an express exclusion of anything over reasonable skill and care, and express exclusion of fitness for purpose. And if people amend contract, I'm afraid I do amend JCT to put an even higher standard of design obligations, such as comply with performance specifications. But if any contractor says, but I'd like to expressly exclude fitness for purpose, I say, yes, of course. I don't think that's usually controversial, apart from if it's a PFI contract. All of those public sector contracts seem to touch on that. And it's been clarified, I think this is the most mind-numbing amendment, that in defective premises, provisions refer not only to the provision of a dwelling, but work to a dwelling. I'm sure that was very important to somebody. I would have inferred that that was the case anyway. But so miscellaneous housekeeping amendments, sorry, A and Bs, RICS, REBA, constructionadjudicators.com, and the Chartered Institute of Arbitrators. Plus any other A and B you want, so stop moaning about it. Otherwise, we'd have to say who's in and who's out. Communications. a load of things have happened since the last edition. Who would have thought that I would be negotiating building contracts on Teams and Zoom and then be able to send my amendments to the quantity surveyor, who then has to create this dreadful PDF, which is 300 pages long and comprises the JCT digital document and the prelims and all the technical documentation or a list of it, and all the warranties, parent company guarantees, etc. And then it gets signed and nobody ever touches any paper, and you don't have those. Anybody ever had those CDs which were in the box with the contract, which got lost many days, years ago, and unfortunately there isn't a list of what's on it in the actual contract. Anyway, none of that happens anymore, of course. There's a specific provision on email, because otherwise how many people would attempt to serve a notice at 5:29 and 55 seconds on a Friday? Critical notices can be served by email, but only to specific email addresses. Can I just warn everybody about that? I think you probably have to put about 3 email addresses. The person that's dealing with it, the person who might be covering for them if they're on holiday, and the default email address which somebody in senior management can find if nobody else is going to see it. There's a whole load of heffalump traps in that one. Attestation has been updated to provide for electronic execution, which we seem to do all the time now. Some banks don't like it for some strange reason with warranties. I have no idea why. And the guidance notes on execution follow the Law Commission report on the subject. Insurers' particulars. This is mine. I'm very proud of it. I'm sick and tired of it only saying it's how much insurance, aggregate or each and every claim, and do you want asbestos or contamination? I don't know, you get these PI certificates and they've got these long lists of aggregate sub-limits and exclusions, and only having those 2 things results in people not reading people's PI certificates and getting nasty shocks later on. Doing fire remediation work and finding that the contractor hasn't got any fire insurance, which would be a bit of a problem. So there's now a space to put in all the categories of cover which are excluded or subject to aggregate limits, reflects the rapidly changing PI market. The list of these things gets longer every year, and people keep sending you certificates that don't have them on. Legislative changes. We've spoken about the BSA. So we did the minimum possible consistent with directing people's attention to the issues that they need to address when filling the contract in. Pop quiz. You're still using 2016. Does the BSA not apply to it? Yeah, a lot of people don't think about it because it's not in the contract particulars. I had this the other day. A well-known firm of quantity surveyors seem to have managed to not think about it because we're still using the same contractors we used on the other package of work, and because the attention wasn't directed to the fact that you need a BSA, PD and PC. Somehow, I think it's going to come as a shock to somebody if they keep. I don't know if anybody's using 24 yet. I mean, it's particularly if you've got one of these tracked jobbies, it's quite easy to follow what the changes are and make and shift any amendments over. But that's another heffalump trap, that somehow BSA doesn't apply because you're not filling in a set of 2024 particulars. Beware. Construction Act, termination accounting payment provisions added to section 8, better late than never. Corporate insolvency, was that an amen I heard? Corporate Insolvency and Governance Act, new insolvency grounds added. I'll speed up at this point. Where are we? Yeah, you speed up. So Building Safety Act, major legislative update. We did actually wait for it. We decided we couldn't wait any longer for anything else. There's new Article 7, there's new particulars. It's very skimpy because, never forget, not everything is a high-risk residential building. It's not got much relevance if you're actually building an office without any accommodation unit. So if you want more information, then you can, on high-risk buildings, then you can go to the JCT website for that, and it's excellent, and we'll We had to debate whether we were going to have a loose leaf supplement. We gave those up some years ago. So the supplements are effectively there on the website about things you need to take into consideration. So the provisions have been amended to reflect especially to the Construction Act's payment regime in Section 8. I don't know why I think John did that animation wrong, sorry. Follows the principles in Section 4 of the contract. And there's a real hodgepodge here. New insolvency grounds, modernising and streamlining. I mean, it's not materially shorter, you'll notice. It's still quite a long contract. Extension of time and unforeseen conditions. What can I say? We seem to be giving more grounds of extension and loss and expense. We spent, back in the day, I had to make up my own COVID provisions, and because every contractor tendering for a job would ask for them. And I did all right, I think, because it's not dissimilar. But of course, everybody said, well, you should now immediately come up with a clause, even before the new edition comes out. And guess what? The contractors and the clients didn't agree. So what you've got is this slightly uneasy compromise whereby an epidemic is an extension event, but it's not a loss and expense event unless the parties agree that it is. So you've got one mandatory and one optional. Time, but not necessarily money unless the parties have agreed. Extensions of time, drafting of notification provisions has been improved, although it's not clear what happens if you don't comply with them. We'll come to that at the end. The timetable has been altered because people, some contract administrators, shock horror, sometimes sit on the thing to use the available time as a sort of cliffhanger, I think. The time to grant an interim extension of time has been reduced from 12 to 8 weeks. The final extension of time review timetable is unchanged. We've got new extension events for epidemics and changes the law after the base date. And it now takes into account the publication of government guidance, which is what I'd drafted all on my own when not finding it on the JCT website. There's a revised provision for antiquities. I'll skip over this, but the process is contractor gives notice of circumstances, including the cause of delay, to give particulars with notice or as soon as possible thereafter. And then the contractor supplies further information as the employer may at any time reason. I don't know why he's crossed that out. The employer has 14 days now from notification or particulars to ask for further information. We had a debate as to what happens if you don't do that. So that may be one for a future adjudication case, I don't know. Time period for employer's response, 8 weeks now. Relevant events and relevant matters, epidemic, not geared to COVID because it would be bird flu next or something. Something that arises after the base date, affects availability of persons, services, materials, or good for the works. We had a lot of debate as to whether lots of people not turning up because they were ill was within a force majeure, because the force majeure was more the restrictions on the working practices, not the supply of labour, which was generally considered contractor risk, and that makes it clearer. Ground conditions, following the NEC really, and I don't like that. There've always been UXBs in my world, but you know, why the heck not? Would those not be covered if you discover those, unless you write them out, which most of us do, and this could lead to extra time and money. We've revamped the provisions on reasonable skill and care, so that is the default. It's not, there's nothing behind that. It is just reasonable skill and care. You shouldn't be able to infer in an absolute obligation. No fitness for purpose. Design liability, it's there in the track changes. We've taken diligence from reasonable skill and care. I was always taught by architect clients that it doesn't matter if you're going to be diligent, it's a context specific thing, it's there anyway in reasonable skill and care. There's drafting for an overall liability cap, but most clients don't want it. And an obligation to ensure subject to reasonable rates and terms. Reinstatement work where option A applies now includes an extension of time, which I'm surprised it didn't anyway. This is, I feel, a fraud, definitely speaking about this, because this contract, God love him, is John Rich's personal baby. And if you don't have one, the following happens. So I had a matter where we were trying to shift a contract which had gone horribly wrong from fixed price onto target cost. And my opposite number, this lovely and very keen young man from Penzance, went off and tried to mix up the NEC target cost provisions with some out of the constructing excellence contract and add them to D&B. You don't have to do that anymore. When this comes out, which will be the tail end of the contracts to be published, there will be a brand new target cost suite. It's very slightly different from the reasoning in NEC. You don't have disallowed costs. So why did we need it? Well, there were law firms out there who were ravening to have a target cost contract, believe it or not. So we had a large law firm, I don't know if it's Penzance or somebody else, saying if you produce one, we will definitely use it. So this was an ideal chance to add another product. When I say product, please don't think we're out to make money. John Rich and I were talking to the King's College Construction Law Association the other day, and we were challenged by somebody who was obviously from the NEC saying you should produce an international contract, it will increase your turnover no end. And we said we weren't really there to make money, we were offering this contract. I know there's a price associated with it, and you'll probably laugh hollowly when I say it's not a commercial organisation, but we really are there to provide what the industry feels it needs. We're not there to make money, because when it's a not-for-profit, you know, the only thing we can do with the money is plough it back into producing the contract or contribute to good works like the Young Professionals Group. So it's a product that people wanted, we've produced it. And funnily enough, in his slide, John has also mentioned the project bank account documentation, which he also drafted. So it's a simple step into the world of target cost. It's not like the constructing excellence contract. There's a target cost subcontract, which is encouraged but not mandatory. You can use any form of subcontract with it. There's a guide. It's based on JCT design and build. It is possible to have design in target cost. And the calculation of costs, not surprisingly, follows the model from prime cost contract. And all the other general changes are included in the suite. I think I'll probably end there, because I'm very interested to hear any questions that you may have, because I've been through the main changes. I mean, we're very proud of it, but it's not perfect. There is, I'm expecting someone to raise it, so I'll raise it. There has been a recent potential embarrassment to do with condition precedents. Does anybody know about that? So JCT doesn't often get challenged on its drafting. It happened at a unique event in Crown Estate and John Molam, where the Court of Appeal unexpectedly found that the issue of final certificate was an estoppel against claims against the contractor. There is a Scottish case which claims that certain provisions of the loss and expense clause is a condition precedent to claiming loss and expense. Now, that is not meant to be the case. It's a Scottish authority. We've been asked what we're going to do about it, to which the answer is nothing at present, because it's not a binding authority. I would be surprised if it's a condition precedent, because I always stick in my own express condition precedence clause, which is like the NEC early warning clause, saying, please, whatever you do, mention something within, depending on the length of the contract, a month. Otherwise, we won't even entertain your application for time and or money. Because I once got taken for a ride, as did my client, by a developer and a contractor colluding to grant an extension for bad weather that happened a year ago and nobody ever mentioned it. So that's what we don't want to happen. But I have to infer from the reaction that JCT does not wish it to be a condition precedent, and we would have to debate what we were going to do about it if in fact a higher authority decided it was a condition precedent. There's an excellent article about it by Robert Reed of the King's College faculty on the subject. So it's be interesting to see what that happens. It's incredibly unfortunate because this is not about something that was in the contract in the new edition. It was something that was already there but which we didn't change, and the case came out like 2 weeks after the contract was published, but it doesn't appear to be a binding authority. So.
Brilliant. Well, thank you very much. And what we'll do is we'll start with some questions in the room, if that's okay. For the benefit of anyone who's online, 2 things. One is I'll just repeat the question from the room so that our mics can pick it up. Okay. And if you're online and you want to ask a question, can you please use the Q&A box at the bottom, and Paresh, who's managing that, will be able to shout them out for you. Should we turn the slides off so people can actually see my smiling face? Can we do that? Yeah. Okay, great. Perfect. You've turn them off already. That's great. Go on, Mark.
Can you explain why the interim decision has been removed or reduced from 12 weeks to 8 weeks?
Because...
Sorry. So the question is, why is the interim decision for an extension of time, I believe, has been reduced from 12 weeks down to 8? Because it was felt that too many contract administrators would use the time available rather than getting down to it. And it's somewhat unfair to the contractor. I think time will tell whether there's actually any sanctions for using a longer period. But I know that, I mean, I've heard employers' agents say to me, but we've got 12 weeks, you know, and they haven't got 12 weeks. They're supposed to do it as soon as possible. Otherwise, it's a massive distraction to everybody on the project. So I think it's an exercise in positive behavioural modification.
Epidemic. In our last exercise, we ended up using 40 euros. In your slides, you said epidemic. Is there a definition of epidemic?
Yes.
Secondly, sorry, you mentioned in one slide that it was a no-cost extension effect. In another slide, you mentioned no cost with it.
Yeah.
So the question is, does the new JCT include a definition of epidemic, and is it with or without costs?
It's a definition of epidemic that is taken away from COVID. It's not, I mean, when I used to draft them, all those 3 years ago, I used to specifically refer to the COVID-19 pandemic. I say mandatory advisedly because it's mandatory as a relevant event, so you get time for it. Yeah. But it's optional in the particulars as to whether the employer will allow you to have money for it. And I think before, there were different schools of thought as to whether the unamended contract gave you anything for COVID. And certainly I told a contractor they weren't getting anything and they weren't entitled to anything, and they went off and accepted that. I don't know if there's pending litigation in that other people know about, but I think also the conventional wisdom was that even if it did give you time, it didn't give you money. So I suppose that the amendment reflects the conventional wisdom that it gives you time and not money, but it's not directed towards the pandemic. It's directed towards, God help us, a future pandemic. Yeah.
Who decides it's an epidemic?
Well, the same person that always decides whether a relevant event has occurred, it's the contract administrator.
An epidemic is less widespread than a pandemic, by definition.
Yes, I think it's a lower threshold because it's not requiring it to be a worldwide event.
Yeah. Right.
I mean, if you look by analogy at those clauses in those insurance contracts, which a former colleague of mine has made an absolute industry of enforcing, that people, I think in those cases, people were entitled to cover for business interruption for an epidemic, not something that was global. So it's a lower threshold than a pandemic. It's an epidemic. It's not meant to be global.
Fresh, we've got anything online?
Yeah, we've got a question online. We've got someone asking, when are the JCT 2024 contracts available for use? And may the 2016 version still be used?
Right.
Yeah, so the question is, when's the new suite of JCTs going to be available for use, and can you still use the 2016 suite after the 2020, the new suite has come out?
That's a many-layered question. So the first contract, this one, the D&B, came out in April. Then it was followed by the minor works suite, the whole suite, including the subcontract and the guidance note. Then it was followed by the minor works suite. I mean, they were basically issued in order of use popularity, and now the intermediate form has come out, and I think that's the only ones for which there is a specific date. But they're coming out sort of monthly in waves, and the target cost contract is meant to be the season finale of the contracts. Cliffhanger. Can you still use 2016? Of course you can, because I have been subjected relatively recently to 2011. You can do whatever you want, except that it might be quite far out of date. Can you physically use it? Yes, you can use a hard copy. Can you use it online? I believe they are switching it off. They're not switching it off until a year after the last contract has been issued, because that wouldn't be very fair. Is it safe to use 2016? Well, the immediate point that occurs to me is it isn't, from the point of view of the fact that you may forget that you may have building safety implications and need a building safety principal contractor and principal designer. And there are a number of other things that, I mean, it's safe to the extent that you have to take into account it lacks the things that the 24 edition has. And the most obvious example of that is the BSA stuff. And it doesn't affect where it applies or not, it applies where it applies, but people may neglect to think about it, as a contract administrator has recently, in my experience, because it wasn't staring them in the face as a part of the particulars, which is slightly dangerous. We're all quite mechanistic in our approach. I'll give you another example. I'm sick of asking a quantity surveyor why he has said that the client is not a contractor for the purpose of CIS. And that they said, well, we just assumed. And I said, well, have you actually asked the client if they are or not? Ask them if they are or are not. If they don't know, then tell them to ask their tax accountants, because if they are and you filled it in wrong, this will happen to you. This is why I wanted the contract particulars on insurance changed. People do what they have on their checklist, and if you don't have the right checklist in front of you, then you go through it mechanistically and you may forget to do something like check if anybody's got any fire insurance under their PI certificate. So I suppose it would be kind of mindful use, but also because it's not, if you remember, there was that big jump, I mean, it really upset the hell out of me, where they changed all the clause numbers. I think it was it 2005? And I've been going, you know, I only just got over calling the insurance clauses 21 and 22, and that's slight exaggeration. But there isn't any huge structural leap that is going to make it difficult to look at this contract. And if you do use amendments, to carefully go through and see which subclause number refers. And if you've got track changes, then make sure you're not missing anything. So it's not going to be, I've already used it twice in anger on 2 fit outs. It's not going to be as painful as it was leaping from JCT 80 to 2005. I assure you, I've used it twice. It was a piece of cake to shift my amendments over to the correct. Mind you, I did know a lot about it already, but it was actually, if you get the track version, you can see where your subclause numbers are going and all that sort of thing.
I have one question, which is, I think you talked about the electronic communication and the serving of notices. And I think if you serve a notice by email, it's deemed served the next working day. Is that correct?
That's what I referred to, because otherwise you'd get dirty tricks.
And that would apply to, say, payment notices as well.
Uh,
Or, well, I suppose my question is, would that apply to payment notices? And how might that impact the, the operation of the Construction Act and the 5 days to issue one?
I'm pretty sure it affects payment notices, and that's why you don't have it. I mean, anybody else seen a house builder subcontract where the pay less notice has to be given before 5 o'clock on the final date for payment? I mean, people will try and get away with what they can get away with. That provision is there to stop people trying to do it at the last moment when everybody's gone home. And please be careful with your email addresses, because how many defunct email addresses have you come across when you're trying to email somebody on the other side that you were dealing with? So you probably need to put in about 3 email addresses. Also, I mean, there seems to be, I've been on the receiving end many years ago when I did used to do some adjudication. People will deliberately serve a company at its registered address, knowing that their accountant, whose address it is, will never work out what it is until it's far, far too late. The same thing can happen with email addresses. The intention is to communicate, not deliberately to fail to communicate with somebody. Let's hope that that bit of behavioural modification works as well. So,
Eddie?
You mentioned something changing the termination.
Termination account. So sorry, the question is the changes in relation to termination clauses, and I think in particular the termination account.
Yes, and we had a slight difficulty with that because if you read it, it almost reads like it's a pay when certified clause, but we couldn't work out how else you would do it. So chapter and verse, I mean, I'll bring it over to you actually later. But it changes 8.8.1 and how you go through that whole process of totting up and set off, really. But in trying to be accurate, I'd be interested to know what everybody thinks about it, because in trying to be accurate, it does risk being contra the Construction Act, but there was physically no way of amending it otherwise, because you can't know when the payment is due until you know when a third-party contractor has finished the job. So that was a really interesting one. But it's frustrating this because we can't get into the details of any of these things in great detail in the time available. But it's a fascinating debate that was had in the JCT about that.
Got another question online. Do you know when the NBS are going to update their preliminaries when you switch contracts, and will they liaise with in advance to help the transition?
So the question is, do we know when the NBS are going to update their preliminary suite to reflect the new contract?
You're asking somebody who works with an organisation that doesn't acknowledge the existence of preliminaries, so don't ask me. We all know what they are, but I'm afraid I personally can't answer that question. We've not been in coordination with them, and it's not something that we, as I said, it's one of the big frustrations I have about JCT, because it behaves as if there's no such thing. You won't find the word preliminaries in a JCT set of terms and conditions, and it's completely different. And I believe now commercial organisation, isn't it? So no doubt one of my colleagues could answer that. But anybody else know the answer?
No, I don't know the answer. I wanted to ask.
Go on then.
Hello, colleague.
You were talking about enforced negotiation and how it doesn't stop a party starting an adjudication at the time as is their right. I ought to know the answer to this. Has anyone given any thought to defining that a dispute is not right, it's not crystallized, until the negotiation process has come to?
So the question is in relation to enforced dispute escalation steps prior to adjudication, and has anyone considered saying that a dispute has not crystallized as per the Housing Grants Act until the dispute escalation steps have been followed.
Right, I'm not a litigator. I predict that that will fail in court, firstly. Secondly, as I said, I think it's mandatory, but it's unenforceable. Thirdly, where you do get people buying into a whole escalation formula, it tends to be on big infrastructure projects. They have dispute review boards, and they have all fully bought into the idea that you go through certain escalation stages, and therefore nothing bad will happen because the parties have bought into that, and they have modified their behaviour by modifying the way that it's dealt with procedurally in the contract, notwithstanding the Construction Act, because it's infrastructure, it doesn't make it outside the Construction Act. And I did ask at a seminar several years ago and learned QC, and I said, this provision, this escalation provision is unenforceable, because in several cases finding all of these things are unenforceable. You can't even stop somebody adjudicating outside the limitation period, as you know. And did she think that it was purely for behavioural modification? She said yes, she thought it was purely, but that we both agreed that that was a worthwhile aim in itself. However, if any of you fancy trying it, I'm sure it will keep you in gainful employment for several months, which I know is what my mischievous litigation colleague here was thinking.
More questions online. It follows on from James mentioned earlier. Can valuations and instructions to be issued electronically under the new suite, or must they go by post?
So the question is, can valuations, presumably payment notices, applications for payment and the like, be served electronically?
They can be served electronically. Be very careful whose addresses you put down.
Just following on from that, sorry to interrupt. You mentioned you've been able to 3 or 4 email addresses. Now, I think we've all been on sites where you can quite high turnover of staff. What happens if, sorry, that all 4 of those email addresses are no longer current? Is there a way to update that?
You'd have, sorry, do you want to?
Yeah, so the question is, where the contract specifies certain email addresses for the service of notices, what happens if those email addresses are no longer in use?
What happens if the one you've currently got, you know, or the one address you've currently got is out of use, or is somebody's, if it's hard copy, somebody's accountant's office? It's up to the parties to make sure that there is a fail-safe person, even if it's the chief executive secretary and his alternative secretary and his alternative secretary, that somebody gets it. But I think the problem is inherent in having a postal address as well, because it's supposed to be your registered address, and your registered address is often nothing to do with the people doing the contract.
Okay, 1 or 2 more?
I've got one more question. It says a lot of procedures in JCT 2016 refer to calendar days as opposed to working days. And, it applies you excluding weekends. And is this being amended to working days?
I think it's been amended consistent with a bit of legislation on the subject of what's a banking day.
Yes, so the question and the answer relates to whether we're reckoning periods by working days, calendar days, and the extent to which that's been updated.
Passed, but I think it has been updated by, apparently there's some legislation that tells you what is a working day, which is to do with banking legislation. Yeah, because nobody does that sort of thing. Yeah.
Okay. Well, Karen, thank you very much for today and coming to speak to us. Can I just ask everybody to join me in thanking Karen for today?